All right. It says you are recording.
Good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our September 23rd, 2021 public meeting. And this meeting is being held via teleconference in accordance with legislation signed by our governor on September 2nd, 2021. I guess the legislation is S50001/A40001 due to the coronavirus emergency. Section 282 of the Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe rent-regulated residences that comply with the minimum standards of safety and fire protection in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. I have one short announcement to start. At the conclusion of the July 15th meeting, I erroneously stated that loft board meeting would take place on September 16th, 2021 at 2 p.m. Obviously that didn't occur while it was actually scheduled for today. However, September 23rd. Immediately after the last board meeting, the Loft Board staff reinforced the correct information on its website. Also, a notation was made in the July 15th, 2021 meeting minutes, noting the correcting this error. I first turn to a vote of those July 15th, 2021 meeting. We have, are there any corrections or comments to the minutes of that meeting? Absent any comments, is there a motion then to accept the minutes?
I'll make that motion.
Mr. Roche, is there a second?
Second.
That's Mr. Hilton. Thank you. Then, Ms. Rivera, could you please poll the board members?
Mr. Barrett,
Abstain.
Mr. Roach,
Yes.
Ms. Tanahashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 abstain.
Thank you, Ms. Rivera. The next thing on the agenda is the Executive Director report. I will now turn over to Mr. Schultz for his time to present his report. Thank you.
Good afternoon, everybody. It's good to see everyone again. Chairperson Hilton already mentioned it, but I'll just mention that yes, due to the ongoing public health crisis, Governor Hochul signed some legislation that in-person board meetings have been suspended, the requirements through January of 2022. The board staff has been working to find spaces, physically spaces, so that if and when we can resume in person, we'll be able to do it safely, depending on what that calls for. So, it's nice to see everyone virtually, and hopefully we'll see each other in person eventually. Another brief update on something we brought up in prior meetings was a bill A7667, which in very short order basically gave tenants some avenues to go to housing court where it was perhaps not so clear. And that law, as of at least 2 days ago when I checked, was still with the legislature and not presented to the governor for signature yet. Let's see. I just wanted to mention very briefly that we've made some updates to our website. Perhaps the most notable one is that we got the right Loft Board members up on the website, and there's some other items and forms that we've been reviewing and updating and trying to make information more and more available for folks. And one of the things that's going to go up there soon let's see if I can find it, is digitally, of course, is this brochure that has been printed, and it's a Know Your Rights Guide for Loft Tenants brochure. So you can find that on our website hopefully very soon. The request has been made to put it up, and if members want a certain number of physical copies, I could probably try to get you some, depending on volume and such. Let's see, another item of brief update. I was asked to give an update on the Soho NoHo rezoning. So as of earlier this week, it was remained under the borough president review, and the environmental impact statement had been submitted. City Planning Commission, City Council, mayoral reviews and votes have not officially started according to the ULURP pipeline that I saw. The revenue, the unofficial Loft Board revenue for July, I'll be covering 2 months today because we had a break in August. The unofficial Loft Board revenue for July was $992,235. The unofficial Loft Board revenue for August was $222,000, $744.80. And that's for August. And I need to note here now, Ms. Rivera, who is there, she's not on camera, but she's part of this meeting every week. She's the one who processed all that money. This was our annual registration period, and she has the expertise and the hard work, and she does it, and it's amazingly well. And I know she doesn't want it, but I'm giving her this public recognition anyway. So thank you, Ms. Rivera, truly for your hard work on that.
And that makes the Loft Board in itself a millionaire, right?
Yeah, I think we just got over. Yeah, we're millionaires for a little while at least.
All right.
Enforcement updates. I want to just mention generally, fall and winter are approaching, and I want any building owners who are listening to make sure that their IMDs have heat and gas, and that the stuff is required, and that it's a life safety. So it's something I very much want to, keep people warm when the winter comes. So please, think ahead. In July and August, there were a total of 37 inspections. Two of those were related to housing maintenance. 2 were related to declarations of intent, and then there were 33 others that were some version of a special kind of inspection, vacancy verifications, maybe joint inspections with DOB, or some other sort of loft board building inspection. I wanted to just point out a few anecdotal inspections. I'm not going to give specifics of the address. I don't think it matters. But another person who doesn't want credit, who I'm going to give credit to, is our inspector, who is working very, very hard. And, in July, I think it was in July, maybe in August, he went out on a reinspection for no gas, speaking of no gas, and his reinspection confirmed that the gas has been restored. And, give credit to the people who restored the gas. I want everyone to know that our inspector is out there checking on that and following up on that, and we're glad to hear that it did get restored. Another inspection, just anecdotally to mention, is when our loft board inspector went out with DOB on a joint inspection. There were concerns about the structural aspects of the building, and so our loft board inspector was able to help get access and communicate to get DOB down there to make sure everything was safe. These are just a couple of examples of, again, the kind of great work that our inspector does. Litigation updates. I have two cases to mention as litigation updates. One is a decision. 475 Owner LLC versus the New York City Loft Board in Coventry, index number 151133/2021. Here, petitioner is an owner, filed in Article 78 to challenge Loft Board Order 4943 that was issued in February of 2020. In that order, the Loft Board found that Unit 1109 at 475 Kent should have been covered under loft law, and its occupant granted protected occupancy status. The board found that the unit's exterior terrace and balcony space should be considered in determining whether the unit met the requirements of the multiple dwelling law, and specifically the at least 400 square feet in area section of that rule. And the owner argued that the Loft Board's interpretation was inconsistent with what the legislature intended, and the court denied the petition, finding that the Loft Board's determination was supported by a rational basis, and that the board abided by the plain language of the statute and was not found to be irrational, arbitrary, or capricious. I believe that is being appealed, or a notice has been filed for appeal. The new case is Stream versus New York City Loft Board. Petitioners are owners of a building at 257 West 19th Street in Manhattan, New York, New York. They filed an Article 78 challenge to Loft Board Order 5039 that was issued in March 18th of 2021. And there, the Loft Board granted coverage and protected occupancy for Ronald Pickler, who is was the occupant of the fourth floor. And in finding that the fourth floor unit was eligible for loft law coverage, the board found that although the unit itself was never used commercially, it still met the criteria, the building, this unit met the criteria for an IMD because a portion of the building had been used commercially. And the board further found that Mr. Pickler was the protected occupant of the fourth floor and rejected the owner's argument that he didn't have valid tenancy. And the owner's argument there was that he'd executed a lease with only one of two owners in common. The owners now, in this new case, argue that the order should be annulled. That's the March 2021 order, because the fourth floor unit is not eligible for coverage due to its long-time residential use, because Mr. Pickler doesn't qualify as a protected occupant. The owners are also arguing in their papers that the validity of his lease was already the subject of a pending action in Supreme Court, New York County Supreme Court, in March when the order was issued. And so the argument is that the Loft Board lacked jurisdiction to make a determination relating to that lease. So that is a new case that's ongoing right now. I have, I think, just one more item. In one of my first meetings, it was asked and suggested that we try to give statistics and updates, and there was a quarterly request for that. So I'm going to share a screen now, and hopefully it will work. And I'm going to walk everyone through these statistics fairly quickly because we have a lot of business to get to. The first slide here relates to the narrative statement conferences and certifications so far this year to date. I'll confess, when we're doing a virtual meeting, it's a little hard to know what everybody sees, so I'm going to do my best to try to make it visible. But this is our narrative statement conferences, our certifications as the year has gone on. Give or take 2, 3, 4, 5, 6, 7, sometimes 8 of each of these. And these are our conferences that we work with the owners and the tenants to move their concerns, to communicate about concerns, and the certifications being the approval at the end of that process, depending on how it goes. The next slide is letters of no objection, which are letters that the Loft Board issues essentially in some that will allow work in a non-IMD space, that will let the process move forward. And there are various things we check as Loft Board to make sure that the IMD units won't be disturbed, and that the loft laws being followed. And so again, looking at the numbers, you see that each month there's several approved. I'll note you see every month that there's really not any denied, and that's because the next line is because there is an interaction by which we work to get the information or the action needed to make something that couldn't be approved. And that's the graphic of those numbers.
Kevin, could you maybe make your graph a little smaller because I think we're missing.
Okay.
There you go. Thank you.
Does that help? Okay. Sorry about that. That's the slide I just went through. This is the total revenue, which just at a glance looks like the one I saw from 2020 because it's got these low and then it bumps up really high, and that's what I referenced before, which is our annual registration. That's where all the money comes in. And so yeah, as I just mentioned, those are the numbers I just mentioned in July and August. The 900, almost a million in July, and then a little over 200,000 in August. The next is a chart of our FOIL request process for the year, 270 so far. So when I'll ask folks to mute.
Okay. Kevin, could you just ask again, members of the public should just mute their phones, please.
Yeah, please mute. And I'm in the screen sharing, so I've been trying to mute people from mine, but with my current screen sharing, I actually am challenged to that. So if you could please mute yourself, it'll help us move the meeting along. Thank you. FOIL requests, 271 year to date, and these are requests for information, from members of the public, practitioners, of the records we have. And Loft Board has an impressive array of records going back a long time. This is our building status of each. We have 327 buildings registered right now as IMDs, and the numbers that you see are an indication of where their status is. Going from top to bottom, ones with alt ones filed are 77 of them, or a little less than a quarter of them. Ones with a permit, that have a permit, 117, 36%. That's our largest group. 73 of them, or 22%, have reached 7B or TCO compliance, which is a threshold under the laws. Another threshold is the C of O, the certificate of occupancy. 5% of them are there. And then another 5% have moved from there to submitting a removal application with the Loft Board. And then the last category here, and I probably will move that to the top next time, is actually the number of buildings, 28, that have not filed for any alt yet in moving forward with the process. So that will be, again, quarterly statistics and key indicators that we'll certainly prepare quarterly. I think that's everything I have to share as far as the executive director's report.
Kevin, two things. One, that report you just made, that's public, obviously. So is that also filed with the minutes?
It was last time, and it will be again. Yes.
Okay. And secondly, the brochure that you mentioned, I believe they were in multiple languages, correct?
Oh, thank you. Yes, 13 languages, I believe.
Right. And so, do you remember? Can you speak any of those languages, or can you just tell us which languages there were?
I'd be remiss to leave one out, but the city has a list of languages that are appropriate and required, and I don't know them. So,
but there you'll at least the website will let us know that those languages are available for.
Yes, I submitted all 13 of them to be put up on the website, and exactly how they organize it, I don't know, but yes.
Okay, great.
I have a couple questions.
Yes, sir.
Number one, on the Know Your Rights Guide, is there a PDF of that currently available?
Yes.
Could you send it out to the board members, please?
Certainly, yes.
Okay. Number two, I think just as a matter of clarification, that the borough president has made her recommendations known on the Soho NoHo plan, and it's now before the City Planning Commission. So the scorecard so far is it was pretty resoundingly rejected by the community board, whose opinion is advisory, and Borough President Brewer was not terribly enthusiastic either. Next question: am I correct that the revenue that the Loft Board enjoys is based on a payment of $500 per unit currently?
Yes.
Yeah, thank you.
Chris Rivera is coaching me on this.
That's who I want sitting next to me.
All right. Okay.
I'm not that smart. I'm just, thank you.
I get her next meeting, sir, to help me with the tough
Okay.
questions.
And then can we go back and take a look at that letter of no objection slide again for a minute?
Certainly. Okay. You see it? Yes.
Yeah. Thank you. And by the way, thanks for providing the statistics. It's really very helpful. My question is that, for example, in January, we show 35 letters of no objection. Is that were filed in January, or is that a cumulative total?
That number is, I think, an indicator of, for lack of a better term, workload. So those are ones that were in our workflow, which is to say they could carry over and over. The ones approved would be representative of what was concluded. When they were received is not indicated here. So that last total would be, again, a kind of indicator of workload, meaning it's underway in one form or another.
So working across the bottom column, if we started out with, it looks like 35. In February, that number dropped to 29 based on the approvals in January.
Mr.
It went up.
39.
Yeah.
I'm just trying to get a handle on whether the numbers for each month on that bottom column are new. Is the total of letters of no objection for the year the sum of those, of the year to date, the sum of those 8 months?
No, it wouldn't be, because the way that we've been reporting them, and we do, this is derived from monthly reports, because they are, I do not know that we have the statistic of like received, which I think might be the statistic you're seeking. I mean, I shouldn't say I know we don't have it. We don't have it prepared. But assuming it's feasible, which I imagine it is, that's something I could add to this.
And I think having the guts to, having put together some PowerPoints that I was then not terribly prepared to explain, I understand the charm of PowerPoints. But when I first looked at this, I thought, my goodness, does that mean we've had 300 letter of no objection applications this year? That's not the case.
Yeah, I don't want to really. I will say I think what you can take is that at any given month you can see how many we were, the totality of which ones we were dealing with, right? So you could say we have between 35 and 61 at any given time.
Right. And so for example, if you look at the last month, which I guess is August, 22 were approved. You add that to the 34 that are hanging around, and that brings us to a total of 56.
Yes, is the universe of the month's efforts in this area.
Got it. If you can cut that a little more, it would be interesting. But I was just, if the board got 300 letters of no objection this year, I was going to be very impressed. But
well, remain impressed, but no, it wasn't that much.
I think Kevin, what we're missing here is just a row that shows received for the month.
Right.
And that's the end of my questions. Thank you. That was very helpful.
Thank you very much. Any other questions? Thank you.
My turn? Thank you, Ken. Thank you. The next thing on our agenda is the appeal and reconsideration calendar. There is one case on the appeal and reconsideration calendar, and the case is Thomas Brigham, Clara Kim, Ingo Gunther, and David Kelly at 72 Warren Street in New York, New York. And the docket numbers are AD 0114 and AD 0115. Mr. Clark will present this case.
Thank you, Chairperson Hilton, board members. The applications docketed as AD 0114 and AD 0115 challenge all actions taken by staff that are premised on the validity of Job 963. In February 2019, the DOB began a special audit for Alt-1 Job 419. On December 18th, 2019, NetLessee filed with DOB Alt-2 Job 963 to address the special audit for Job 419. In February of 2020, NetLessee filed with the Loft Board amended plans and an amended narrative statement for Job 963, with proof of service of the amended narrative statement on the tenants of Units 2E and 4E. In August 2020, NetLessee requested a narrative statement conference with the Loft Board. On September 8, 2020, staff directed NetLessee to serve the amended narrative statement on all occupants of the building. On November 16, 2020, staff conducted a narrative statement conference between tenants and NetLessee to discuss issues related to Job 963. On December 4, 2020, NetLessee requested a certification letter from the Loft Board for Job 963. On December 21, 2020, staff started a 40-day clock, which allowed tenants to submit comments or an alternate plan to NetLessee's narrative statement and plans for Job 963. On January 20th, 2021, Mr. Brigham filed an application seeking an annulment of all dispositive actions taken by staff that are premised on the validity of Job 963. Staff docketed the application as AD 0114. On January 30th, 2021, the 40-day clock expired. On February 4th, 2021, tenants filed an application seeking an annulment of the staff's actions related to Job 963, including starting the 40-day clock. Staff docketed the application as AD 0115. On February 16th, 2021, NetLessee filed an answer to AD 0114. On March 1st, 2021, NetLessee filed an answer to AD 0115. On March 15th, 2021, tenants filed an addendum to AD 0115. And on May 4th, 2021, NetLessee answered tenants' addendum. Pursuant to 29 RCNY Section 1-07.1, a person aggrieved by a written determination of the Loft Board staff may appeal the determination to the Loft Board. The standard of review for the Loft Board is whether the facts found are supported by substantial evidence in the record, whether the law was correctly applied, and whether the penalty imposed is appropriate. But it may not consider any evidence not presented to the Loft Board staff or Loft Board hearing officer unless good cause is shown as to why the evidence was not previously available. Tenants' appeals seek to discontinue and annul all actions taken by staff based upon the validity of Job 963. With respect to Job 963, staff determined NetLessee must serve a copy of the amended narrative statement on the occupants of the building. Staff scheduled and held a conference with NetLessee and tenants, and staff issued a notice of a 40-day clock after the conference. For the board to make a determination on the appeals, it must decide if the actions taken by staff were proper pursuant to Loft Board rules. As a preliminary matter, NetLessee argues the tenants did not meet the standard of review pursuant to Section 1-07.1D. NetLessee argues tenants were not aggrieved by staff's administrative determinations because the proposed work related to Job 963 does not take place in their units, and tenants had an opportunity to file comments for an alternate plan challenging the proposed work during the 40-day clock. However, pursuant to section 2-01D2X, proposed work need not take place in the IMD unit for the occupants to dispute the work. The work need only unreasonably interfere with the occupant's use of the unit for the occupant to dispute the proposed work during the 40-day clock. Furthermore, one of tenants' arguments in the appeals is that staff started the 40-day clock based on net lessee's incomplete amended narrative statement, which failed to list requisite details of the proposed work, and therefore tenants were denied an opportunity to properly comment during the 40-day clock. The proposed order finds tenants persuasively demonstrated that they are aggrieved parties. With respect to the first administrative determination, the proposed order finds staff properly required net lessee to serve all occupants of the building with the amended narrative statement, as section 2-01D2X expressly states that if the owner amends the legalization plan initially submitted to the Loft Board, it must file proof of service of the narrative statement on all occupants of the building with the Loft Board. With respect to the second administrative determination, the proposed order finds staff's decision to schedule and conduct a narrative statement to help the parties resolve outstanding issues related to Job 963 was appropriate and did not prejudice tenants. With respect to the third administrative determination, the issuance of the 40-day clock, tenants argue that it should be annulled on 4 grounds. First, tenants argue the net lessee's subsequent changes to the PW1 for Job 963 superseded and invalidated the prior PW1. Tenants argue these changes were so significant it required net lessee to make changes to the plans and narrative statement referenced to in the notice of the 40-day clock. Tenants argue that because changes were required and net lessee did not serve tenants with a new amended narrative statement, the 40-day clock must be annulled. However, amendments to the PW1 do not invalidate a clock. Amendments to the legalization plans require compliance with the filing requirements set forth in section 2-01D2X, and a new clock can be issued for any changes before staff issues a certification letter for those changes. Next, tenants argue that they did not have access to a valid set of plans because net lessee failed to file amended plans with the Department of Buildings. However, section 2-01D2X does not require owner to file plans with DOB. The rules require net lessee to file the plans with the Loft Board, and there is no dispute that net lessee filed the plans with the Loft. Net lessee filed the plans referenced to in the 40-day clock with the Loft Board. Tenants could have requested from the Loft Board or the net lessee a copy of those plans to review. Next, tenants argue net lessee did not meet the requirements for obtaining a letter of no objection from the Loft Board pursuant to section 2-01D4I, and therefore the clock should be annulled. However, letters of no objection are only issued by the Loft Board when owners' proposed work does not affect the IMD spaces. Here, net lessee's proposed work affected IMD spaces, and therefore, pursuant to section 2-01D4II, net lessee was required to obtain a certification letter from the Loft Board, not a letter of no objection. Finally, tenants argue the 40-day clock should be annulled because the narrative statement was incomplete. Tenants argue that net lessee failed to satisfy 2-01D2V because it failed to list non-compliant conditions and code citations in its amended narrative statement. The proposed order agrees with tenants. Here, on net lessee's amended narrative statement, under the column non-compliant condition addressed, net lessee's narrative statement simply says to address open items in special audit for job application 1205-86419. This description is insufficient. The special audit net lessee referenced specifically lists non-compliant conditions and code citations, and net lessee should have included them in the amended narrative statement. Net lessee's failure to provide all available information that tenants were entitled to have in the amended narrative statement denied tenants a fair opportunity to comment during the 40-day clock. Therefore, the proposed order before you today grants tenants appeals solely on the grounds that Net Lessee's amended narrative statement was incomplete and annuls the 40-day clock.
Mr. Clark, thank you very much for that comprehensive analysis there. Do I have a motion then to accept this case? Mr. Delaney, Ms. Heather Roslin is seconded. Do I have any comments on this case? Oh, I'm sorry, Mr. Rivera, you must poll the board members? Or do I?
Comments first.
Huh?
Comments.
Comments first, yes. Do I have comments?
I would just add that this is a very complicated and interesting case. It's worthy of study as to how the board's rules and the Department of Buildings procedures interplay with each other. I commend Mr. Clark for going through all this and writing up what is 8 pages of fine print and explaining why some arguments did not prevail, but why one argument did prevail. And if the 40-day clock notice for job 963 is annulled, that, am I correct that that means that there will be a subsequent narrative statement conference?
To answer that question, it doesn't necessarily mean that there will be another narrative statement conference. However, the Loft Board staff will not issue a certification letter until a valid 40-day clock expires, or the owner submits waivers of the narrative statement process. So it basically means the process is not complete, and the Loft Board staff will not issue a certification letter for that job until the process is complete.
Thank you.
Welcome.
Floor is open to anyone else who may want to comment, just indicate. Absent any other comment, Ms. Rivera, could you please poll the board members?
Mr. Bowers?
Yes.
Mr. Roach?
Yes.
Ms. Hayashi?
Yes.
Mr. Hilton?
Yes.
Mr. Delaney?
Yes.
Ms. Roslin?
I recuse myself.
Ms. Otto?
Yes.
Ms. Rajan?
Yes.
Chairperson Hilton?
Yes.
8 in favor, 1 recused.
Thank you, Ms. Rivera. There are 3 cases on the summary calendar, and these cases are Bamboo Hills Corp. The address is 255 through 265 McKibben Street in Brooklyn, and that docket number is LS 0275. The next case, Matthew Virtue, and that address is 250 Moore Street in Brooklyn, New York, and that docket number is PO 0099. The next case is Scott Dennis, and that is 1087 Flushing Avenue in Unit 302 in Brooklyn, New York, and those docket numbers are PO 0141 and TA 0278. Is there a motion to accept these cases?
Don't move.
Mr. Bowers, Mr. Hilton, is that you? Was that
Yes.
you? Yeah, Mr. Hilton has seconded. Before we go on, there's a caller that needs to mute their phone because it disrupts the meeting. So Kevin, I think I identified the caller as number 9. So could you maybe force that? Thank you. All right. Are there any comments on these cases? Mr. Delaney?
Yes. I just want to note that case number 3, 250 Moore Street, and case number 4, 1087 Flushing Avenue are both cases that are settled by stipulation. And yet again, the Loft Board uses that stipulation as a reason to determine that the case is settled, but takes the delicate position of neither accepting nor rejecting the remaining terms of the stipulation of settlement. One of these was a case that included protected occupancy and a rent adjustment. The other was a protected occupancy case. In both instances, the stipulation speaks to issues of rent and various other things. And I still think that this process is not fully under control by the Loft Board, and that if there are things we don't accept about a stipulation, we should highlight what those are rather than leave the parties guessing exactly what we mean by neither accepting nor rejecting. I think it's a bit too coy.
Chuck, I'm sorry. Elliot, I just want to clarify. Chuck, I think this has come up just about every month. I think we had, I'm trying to remember what we had said that we could possibly do. I know the contents of a stipulation is sometimes private and so on, but what was the suggestion that came up before about what the Loft Board could possibly do to make it clear? Put a list out of certain things that are not acceptable in stipulations?
I don't recall that thorough a discussion. I know we discussed deeming things withdrawn in terms of a way to dispose of them on the calendar. I don't know if we've had that discussion.
We've never had it, yeah. Okay, Mr. Browers. Yeah.
Well, I was just going to second what in fact you said. It is a little frustrating for these stipulation agreements to not be terribly clear. And it's been going on as long as I can remember. And frankly, I don't know what to do about it. Maybe we could get together at some point privately with some of the lawyers on the board and see whether we could make this more explicit for us.
Thank you. Are there any other comments on this case? These cases? Thank you. With absent any comments, Ms. Rivera, could you please poll the board members?
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton. Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
9 in favor.
Thank you, Ms. Rivera. There are 18 cases on the master calendar, and the first is a removal case. 269 Meserole Realty LLC is the applicant, and the address is 269 through 271 Meserole Street in Brooklyn. The docket number is LE0726. There's no staff presentation on this case, so I would entertain a motion to accept this case. Mr. Bowers has made motion. Do I have a second?
Second.
Mr. Hilton. Thank you. Do we have any comments on this case? Very good. No comments. Ms. Rivera, could you please poll the board members?
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Mr. John,
Yes.
Chairperson Hilton,
Yes.
9 in favor.
Thank you, Mr. Rivera. The next case is applicant Julian Bozeman at 475 Kent Avenue in Brooklyn. That docket number is PO0075. Ms. Lynn will present this case.
Thank you, Chairperson. Case number 6 in the matter of Julian Bozeman is a protected occupancy application filed by the tenant of Unit 905 at 473-493 Kent Avenue, Brooklyn, New York. The owner opposed the tenant's application on the grounds that the unit had been deregulated by the sale of rights by the prior tenant, Lisa Moorhurst. This case was first decided in June 2020 in lawful order number 4987, which granted tenant protected occupancy status, but in doing so did not review or consider the post-trial memoranda filed by the parties. Lawful order number 4987 was vacated and remanded back to the law court staff to ensure that the briefs are duly reviewed and considered. After review and consideration of the full record, this proposed order finds Ms. Moorhurst's sale rights to be invalid and finds Mr. Bozeman to be the protected occupant of the unit. Ms. Moorhurst's affidavit was properly admitted into the record by the administrative law judge. CPLR requirements for out-of-state affidavits are inapplicable to administrative proceedings. As the affidavit was offered and accepted into evidence by the ALJ, consistent with those rules of evidence, the affidavit was appropriately relied upon by the Loft Board. This proposed order finds that Ms. Moorhurst's sale of rights is invalid. Although Ms. Moorhurst was the unit's prime lessee, she did not qualify as a protected occupant, having vacated the unit in summer 2009. By the time the building was registered as an IMD in November 2012, although prior owner listed Ms. Moorhurst as a protected occupant of the unit, she had not lived there for over 3 years. Further, even if Ms. Moorhurst could be considered the unit's protected occupant, her sale of rights would nevertheless be invalid because she was not the residential occupant of the unit at the time of sale. The law and rules are clear that the sale of rights must be effectuated by the residential occupant. By the time prior owner purchased Ms. Moorhurst's rights in November 2014, she had not lived in the unit for 5 years, and the unit was occupied by Mr. Bozeman. The proposed order also finds that the purported waiver of rent regulation in Mr. Bozeman's lease is invalid, as the law does not contain a broad exception, and there is no indication of sale of rights by Mr. Bozeman. Mr. Bozeman has also produced sufficient documentation to establish the unit as his primary residence. Therefore, the proposed order finds that Mr. Bozeman is a protected occupant of the unit.
Thank you, Ms. Lynn. So do I have a motion to accept this case? Mr. Delaney, is there a second?
I can second.
I'm sorry, I saw Mr. Bowers. Mr. Bowers is second. Do I have any comments on this case? No comments. Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Abstain.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 abstain.
Thank you. The motion carries. The next case is a removal case, and that applicant is 108 through 114 Worcester Street Corp. And the address carries the name of the corporation, 108 through 114 Worcester Street in New York. And docket number is LE0603. There's no staff presentation on this case. So do I have a motion then to accept this case? Ms. Hayashi, did you raise your hand or you're just?
I'm sorry, I'm just
joking with you, yeah. Do I have a motion to accept this case?
I so move.
Thank you. Ms. Hayashi is moved and Ms. Rajan has seconded.
Sure.
Yeah. So do I have any comments on this case? Absent any comments? Then, Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
9 in favor.
Thank you. The motion carries. The next case is, and please forgive me if I botch the names, but it's Alosha Somlarski, Nicholas Palum, and Scott Tumulty. The address is 239 Banker Street, Unit 4A, Brooklyn, New York. And that docket number is PO0142. Ms. Lee will present this case.
Thank you, Chairperson Hilton. This case involves a protected occupancy application that was filed in September 2020 by Mr. Smolarski, Mr. Palin, and Mr. Tumulty, the then residential occupants of Unit 4A in the building located at 239 Banker Street in Brooklyn, New York. No answers were filed in response to the protected occupancy application. The Loft Board staff transferred the case to oath for adjudication. In May 2021, Mr. Smolarski and owner executed a stipulation of settlement whereby, among other things, Mr. Smolarski consented to vacate owner's default in answering the protected occupancy application, and owner recognized Mr. Smolarski as a protected occupant of Unit 4A under the Loft Law. In addition, Mr. Smolarski represented that Mr. Palin and Mr. Tumulty had vacated the subject unit. Mr. Palin confirmed that he no longer resided in Unit 4A and withdrew his protected occupancy claims. As to Mr. Tumulty's protected occupancy claims, they remained pending at oath and were scheduled for trial. In June 2021, Administrative Law Judge Kara J. Miller issued a final notice of trial, which indicated, among other things, that a trial would be conducted on August 27, 2021. Because Mr. Tumulty had failed to appear at previously scheduled conferences, and because Mr. Tumulty did not contact oath to request an adjournment, Judge Miller marked the August 27th trial as final against Mr. Tumulty. On August 27, 2021, Owner's Counsel appeared at trial. However, Mr. Tumulty failed to appear. Owner's Counsel then moved for dismissal of Mr. Tumulty's protected occupancy claims. Judge Miller ultimately recommended that Mr. Tumulty's protected occupancy claims be dismissed for failure to prosecute. Because Judge Miller marked the August 27th trial as final against Mr. Tumulty, because Mr. Tumulty failed to appear at trial, and because Mr. Tumulty neither contacted oath nor submitted a written request for reinstatement of his protected occupancy claims within the prescribed 30-day period as set forth in 29 RCNY Section 1-06K4, this proposed order agrees with Judge Miller and dismisses Mr. Tumulty's protected occupancy claims with prejudice for failure to prosecute. Furthermore, this proposed order deems the protected occupancy claims of Mr. Smolarski and Mr. Palin to be resolved. Mr. Palin withdrew his protected occupancy claims, and Mr. Smolarski is recognized as a protected occupant of Unit 4A. This proposed order neither accepts nor rejects the remaining terms of the stipulation of settlement that was executed in May 2021. This proposed order directs the Loft Board staff to update the Loft Board's records to reflect Mr. Smolarski as a protected occupant of Unit 4A.
Thank you, Ms. Lee. Do I have a motion then to accept this case?
I can move.
That was Ms. Rajan. I do have a
Yes.
second. I think I see Mr. Delaney's hand. Thank you. I'm open to comments on this case. No comments. Ms. Rivera, could you please poll the board members?
Mr. Bowers,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Abstain.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 abstain.
Thank you, Ms. Rivera. The final 14 cases are failure to register cases. There is no staff presentation on these cases, but I'll read painstakingly the applicants and the information. I do have to read it all, so just for the record. Vestry Holding Corp., 37 Vestry Street, New York, New York, FO 0916. J. Hudson LLC, 15 J Street, New York, New York, FO 0917. 120 Prince Street LLC, 128 Worcester Street, New York, New York, FO 0924. Emspring, how do you say that, Kevin? Emsper LLC, am I good? Is that good enough? Empress Green, okay, 47 through 49 Green Street, New York, New York, FO 0925. 47 West 28th Street LLC, that docket number is 47, excuse me, that address is 47 West 28th Street, New York, New York, FO 0937. Camilla Shah, President, at 354 Bowery, New York, New York, FO 0938. 17 Leonard Properties LLC, 17 Leonard Street, New York, New York, FO 0939. Soho Towers LLC, 475 Broadway, New York, New York, FO 0944. Heimel Realty Corp., 209 East 2nd Street, New York, New York, FO 0945. Bridge Associates of Soho, Inc., 533 Greenwich Street, New York, New York, FO 0952. Redsky JZ Roebling LLC, 143 through 153 Roebling Street, Brooklyn, FO 0969. Regency 175 LLC, 360 Jefferson Street, Brooklyn, New York, FO 0972. 223 15th Street LLC at address 223 15th Street in Brooklyn, FO 0978. And finally, 450 Broadway Owners LLC at 450 Broadway, New York, New York, FO 0983. Since there is no staff presentation on these cases, so do I have a motion to accept these cases?
I so move.
Mr. Bowers, is there a second?
I'll second.
Mr. Roche, thank you. Are there any comments on these cases? Yes, Mr. Delay.
First off, I want to commend the staff for being able to bring so many failure of owner to register cases to the board at its September meeting. Obviously, the deadline for registration is pegged to the fiscal year beginning July 1st, which is why we see so much income in July and August. And in past years, these cases have not made it to the board until October, November, or even December, which in essence gives owners kind of a free pass to not register or renew in a timely fashion. And I'm of the opinion that registration is essential, that if you expect people to perform code compliance and draw up plans and pull a permit and participate in the narrative statement conference, then the place to start is by registering the building. And it's also very important because with the registration, the registrant is required to provide a 24-hour contact number and other information about the ownership that can be crucial in certain circumstances. This year, and I don't think it's the first year, The most egregious offender is a building at 533 Greenwich Street, which last registered in fiscal year 2008, which would have begun in 2007, I think, back when George W. Bush was president. So that's an extraordinarily long period of time to thumb your nose at the loft board. And so there's another from 2018 and two from 2018. Most of them just missed this year, a few missed 2 years. The fines run anywhere from $5,000 up to $17,500 for 3 of the buildings that have gone for an extended period of time. So my first question is, are there more buildings that have failed to register, or is this the entire universe?
There are, I believe, 2 or 3, I'm going to say maybe 4 or 5, that are not on this list because there was some response that warranted review. And so that response will be reviewed, and then a recommendation will be made to the board. These represent, frankly, ones that where we received nothing, either nothing at all, or if anything, and I think it's nothing meritorious or mitigating or compelling.
Fine. My concern is really just if there were 40 more that hadn't registered, I'd have a higher level of concern.
No, they're not. They're not. If there are more, it is single-digit more, depending on the circumstances.
Yeah, and those are kind of chestnut cases where there's wrinkles and plot lines to reconsider. My second question is, would you consider taking the 3, the gold, silver, and bronze of foot draggers, namely 533 Greenwich at FY08 and 354 Bowery and 209 East 2nd, and consider that those might be buildings where some kind of extraordinary enforcement action like specific enforcement might be warranted? Would you be willing to take a look at that?
Yes, we'd be willing to take a look at that.
Okay.
Sorry, Mr. Delaney, but along those same lines, are there outstanding fees beyond these fees? Is this just the currently imposed fees? Are there ever then unpaid fees like in the background?
I see Mr. Argov, who I'm glad he's nodding because he deserves so much of the credit for doing the work here. Mr. Argov, do you want to answer that question?
Sure. So just very briefly, can you hear me? I unmuted myself.
Yes, yes.
Very briefly, as an example, 533 Greenwich Street, I believe the total fees they owe were somewhere in the ballpark of nearly $250,000. This fine that they're getting imposed now is a penalty for not registering for 3 years or more, but they have previous penalties from past FOs. We've issued other summonses they've been issued, and the registration fees. So this is just what is currently being imposed on them for their violation. It is not an encapsulation of all the amounts they owe to the Loft Board.
That's really interesting to hear. Also, I thought that the maximum fee went from $17,500 to $25,000. Am I wrong about that?
No, you're not wrong. The MDL changed it to 25,000, but the rules for this, at least, and maybe for all so far, have not been increased. So we are bound by what the rules say at this time.
So yeah, just to clarify, Mr. Barr, the maximum penalties have been authorized to go up to 25,000, but our rules need to be changed to effect that if the board wants, so that we can get more stringent penalties. You may or may not want that. But Glenn, thank you so much. I appreciate your efforts on that. I have another question though, Kevin or Glenn. When we write these orders for those recalcitrant folks who do this every year and amass, the latest order that we generate, why couldn't that be the cumulative amount of the debt?
We'll look into that. I think probably because what we're trying to specifically enforce is a specific action. And so, the cumulative enforcement or collection might be a different question that we can I'm happy to look into.
I see. And to follow up on Mr. Delaney's question about the enforcement, additional enforcement, what were you thinking?
Of looking into it. No, I really don't want to brainstorm enforcement actions on the fly because I want to make sure they're done right. But I certainly would imagine that if there's an avenue, and I confess I don't know, the law department I think has some avenues for collections that I think would be worth looking into, and I say that without really making any promises or being sure. To the extent that these are buildings our inspector could go take a visit to, that is another action to review their code compliance status and compare it to the rules and expectations, and if there's any failings there. So as I said, I wouldn't brainstorm, but I just did it.
Yeah, that's great because it would. I mean, I'm sure collections would be part of the enforcement, but and I guess we can probably pursue that. But when folks are not paying their debt or registering their buildings as required, that could probably indicate, the broken windows theory. That there are other issues that may be out there that we may want to step up enforcement, surveillance, that kind of thing, to make sure to see if they're lacking other things. So that's great. Thank you for doing that, and I want to thank the staff actually, from Ms. Rivera up to you, Kev, for taking such swift action in getting these out. I think the earliest ever. And so this is great, and I think we did have a talk about this, and those that are remaining do have stuff to be looked into, right? Why we couldn't actually put them here on this, right? We still have some research to do. Maybe some issues were raised that you had to still get addressed before we can do that, right? And
yes.
And you think we'll be able to get this quickly? By Ms. Rivera is nodding her head. You can't see her, but I think she anticipates a question that we probably will be able to get this out by the next board meeting.
We should. I would imagine the goal would be to have those resolved for next meeting. Yeah.
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 Thank you.
All right, and I thank you for the gratitude. I won't be humble. It wasn't easy. It's not easy at all. Mr. Arkoff and other members of the staff worked very, very hard to make this happen.
Delaney.
I have one more point. And by the way, Ms. Roslin, thank you for raising the question you did. That's certainly pertinent. And some of these buildings, as Mr. Arkoff pointed out in the case of 533 Greenwich, they're just letting the meter run and the things rack up. So my final request is, one thing we don't do with the failure of owner cases is we do not treat the IMD tenants in these buildings as parties to the case. So the tenants in these buildings, and there may be a significant number of them because we've got what, 20, we've got about 13 or 14 buildings here. The tenants are unaware that their building's not registered. The tenants are unaware that their owners are being fined. The tenants are unaware of those circumstances. And I think that's, I've discussed this a couple of years ago with the then executive director, but it seems to me the tenants, the IMD tenants that we know of in these buildings should be notified of this action.
One more point in regards to 533 Greenwich. My understanding, the building is in bankruptcy, and it's actually sectioned to be auctioned soon, and their bankruptcy is in part and parcel. They haven't been able to keep up payments going through the loft board process. So I mean that is a reason why they're behind.
Okay, that would be. Thank you for that information, actually, because
I think the loft board is a part of, or there's some awareness of the proceedings.
Thank you, Mr. Hilton. Kevin, have you gotten any kind of notice, any kind of thing from the law department?
No, I'm gonna look again. I know I've gotten one before. I didn't recall it being that one, but you know, the one I got was months, like 6 or more months ago. It's the same
we sure
one.
don't
I
want a bankruptcy action to go with our debt not included in there.
Yeah. I'll review it. Yes, review it.
Thank you for that, Mr. Hilton. If you know of any more, please let us know.
I agree with Mr. Hilton, and I appreciate him bringing that point to the fore. And it's my understanding the building's been kind of marinating in the bankruptcy tub for 4 or 5 years. This is not something new. Whatever stellar management, I don't think this building is chock full of loft tenants, but whatever their financial problems are, I'm sure owing the loft board plus or minus $250,000 is one of them. But it would be very interesting to know how this building got into such a sad state, given that it is in Tribeca, and one would think there'd be a way to bring it to a healthier state of being. But I'd like to go back to my question regarding notification of the IMD tenants in this building.
Before you say anything, I'm wondering, Chuck, you're asking that they be parties or copied on the parties to the action, or just copied on the notice?
When I raised this a couple of years ago, I got the answer that they're not parties to the case, which I agree, that makes sense. They have nothing to do with it. However, they are, it does have an effect on the nature of their tenancy that I think they have a right to be informed.
So I'm not too ashamed to admit that this was my first registration rodeo. So by my second one, which is a whole year away, which seems a long way away, but we'll be here, we'll work to get an answer to that question.
Well, I guess I'd be a little more impatient and say if you get a chance to research the request, and 3 weeks from now you find out that, hey, there's no reason we can't notify the tenants and send them a copy of the order. It's a public document. And if our goal is to try to make these buildings work for both the owners and the residents, having the residents know that the owner hasn't registered seems relevant to me.
Okay, we'll be looked into.
Thank you.
In terms of 533 Greenwich, also it would appear that rents had not been paid for over 20 years in past litigation, and that probably precipitated the default.
Kevin, I'm sorry. When the loft board, when there's any kind of action in an IMD, and it affects another tenant or another party in the building, the loft board has to give notice to the affected parties, right? Whether or not they're part of the action.
Affected parties are defined in our rules in a few different places, and I'm going to say in a few different ways, and then I'm going to ask my staff to jump in and correct me as they are so good at doing. My part of my answers depends on the circumstance, but the short answer is yes. Building occupants are required to get notice of various actions, plans, filings, clocks, things like that.
Right. So I'm just wondering if this kind of fit into that in terms of notice.
Yeah.
Effective.
I mean, I'll take a sharp look at the rules. It might be there and I've never looked at it before. It might not be there, which also might be the answer. If any of my truly brilliant staff knows the answer, they could throw it out there.
Right.
We'll give it a look.
Yeah, but I just want to go back to Mr. Hilton's comment because light bulb just came up. You know, there are payment plans that are available through the Loft Board, so folks don't have to get that backlog in monies owed. So if an owner is really conscientious about doing right by the city, by their tenants and so on, they can come into a payment agreement with us. Otherwise, it turned out to be what it is now, right? You know, where you kind of lose everything. But thank you for that. Do I have any other comments on these cases? Absent any other comment, Ms. Rivera, could you please poll the board members?
Mr. Powers,
Yes.
Mr. Rowe,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseman,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Mr. Jean? Is there someone else? Me?
yes, Chairperson Hilton.
The chair votes in affirmative. Ms. Rajan is not available, so abstain.
Right here. I'm right here. Sorry about that.
Ms. Rajan is on. Is
At
that
the open door.
an affirmative yes, Ms. Rajan?
Yes.
Yes.
9 in favor.
9 in favor. Thank you. And again, I want to commend the Loft Board staff in getting these out and for raising the awareness. You know, I think the executive director did send out, correct me if I'm wrong, did you not send out a notice early to the owners saying, you know, this is coming up and we're going to enforce quickly?
Yeah, there was a letter included in the registration materials that hasn't traditionally been there, spelling out what our, the rules say about enforcement of the registration.
Right. Well, I thank you and the staff for everybody, Glenn, for your efforts here also. So the next thing on our agenda is rulemaking, and this is where I will give an official 2-minute break before we begin so that folks can get a snack, that kind of thing. Thank you. So we will take a 2-minute break. Could you please put yourself on mute and take yourself off camera if you don't mind? Board members, when you're ready, could you just put yourself back on camera so I know? Okay, I think we have quorum. I still waiting for some board members to show up, but we have quorum. So we're back on the record. And the next item on the agenda is the rulemaking updates, and Mr. Schultz will lead the discussion with the help of Ms. Lynn and Mr. Clark. Thank you.
All right. Thank you, Chairperson. This is picking up where the board left off in May. And so, what we're looking at the exact same document that we passed in May. It's what's being referenced. There's been no additional changes made to it, but certain sections are just noted and highlighted. And then I have some talking points that I'm going to talk through. I didn't want to go making changes to the document we voted on, lest it create confusion over what we already agreed to and didn't agree to. So the comments that I have to go through are results of feedback with from the law department and a little bit of interaction with the law department, but there's more interaction to be had, which is to say, what we hope to get through today is less than half, I will say, of the additional kinds of comments we need to work through based on what the law department said. Now, I suppose I'll use the, sorry?
I'm sorry to interrupt, but I think since we last discussed rules, maybe for the public's sake, we should probably just inform them of where we left off and what's happened. How do we get to where we are right now? I'm so sorry.
No, that's okay. And my next comment might ask me to have someone else explain how we got here, because what I was about to say was I got here in April, and I can tell you where I started from, which was really just polishing up a few items. Well, not that it was small, but it was certainly towards the tail end in May of kind of getting the board to a place where they had a draft set of rules where you guys had worked so hard for years getting to that point. So it's going backward. I mean, I know enough to know that the board spent many years going over the rules to make changes to reflect changes made to the multiple dwelling law, to have our rules reflect those updates. And while doing so, some other things were updated for format, and some other things were looked at by the board for various substantive type of things to update and change. That led a very long path led to May, where a draft version was passed by the board that then went to law department for a review. And law department had already been reviewing it as it went along, but this is all the steps of rulemaking. And the draft also went to City Hall for them to have a look at it. And now we are back. After law department looked at it, they have more to say, and it's relatively small compared to the huge amount of things that the board dealt with for years, but I can't say it's insubstantial. Some of the things we look at here today are real just formatting things, and I didn't want to take for granted a single change in these rules without making it the board know and the public know. So is that, I'll leave it to anyone else to give a better update.
That's what I wanted, Kevin, just so
Okay.
you can know where we are. Thank you.
All right, great. As I said, this is a list of roughly 14 items, and these are amongst the simpler of the items that the law department has given feedback on. I'm still working to interact with the law department to get as much clarity as I can on some items, so that when we speak in these meetings, this valuable time, it's as efficient as it could be. And I'll also just, I suppose, for lack of a better word, make the confession, or just make it clear to everyone that, as one of the newer people here, I wasn't party to a lot of the conversations. So if some of this is familiar territory to some of you, please speak up, and I'm all ears. I did go through records as best I could. If these are things that, to be honest, one considered already resolved, at least as far as law department, there's still more to be said. So I'm all ears on that. Before I start going through the notes, kind of page by page, is there any questions or broad comments any of the members want to make on rulemaking? Okay, great. Ms. Lynn and Mr. Clark, you guys have carte blanche to speak up, to correct me, to step on me, and make sure whatever I'm saying is right, because you certainly have more experience than I do on this with the history. So starting off on the draft that was passed in May on page 15, and then throughout about 2, 3, 4, 5, 6, 7, 8, 9 more times, 10 more times, the word affected party was not capitalized consistently throughout. So law department noticed this, and it's been basically the recommendation would be to change it throughout for consistency. It is a term of art that is capitalized in some places and not others. So if there are thoughts or comments on that, I'd certainly want to pause. But I don't, as a lawyer, I don't have much to say about it other than our stuff should be consistent. All right, great. The next one's a little meatier. On page 17, this is the section that talks about, it's a section D at the bottom of the page, and the title as stated, and this is I think the drafting of it, I think, was largely built from what existed already. And the language as stated says, waiver of service due to financial hardship. So this is about applicants who might have substantial hardship, and the service requirements may be more than they could financially handle. So there's an opportunity for the loft board to review that circumstance and relieve them of having to do the service. The reason this was flagged by law department is because they believe, and I agree, that saying it's being waived isn't really an appropriate description, because what's really happening is we're doing it for them. So the way it's really, so the language suggested is that service by loft board staff based on financial hardship, and then the language below I edited to reflect that. That's the nutshell. Does anyone have any thoughts or comments on that perspective and that description of what's happening?
Is it a waiver of fees due to financial hardship?
Well, there's no fees, so service.
No fees.
Yeah, it's not really. Yeah.
So this waiver of service is the proposed.
No. The proposed is in my notes that I shared. What you see in yellow is unchanged from what we already had. Okay. So I thought about trying to provide a version but I didn't. I wanted to be clear on. I wanted to do it as talking points, and then share with you a written version that can actually be voted on. But the title, and this is in the materials I shared in my email. It's a bullet list in my email if you want to look at it. But the title that I think more accurately describes what's happening here is service by loft board staff based on financial hardship. So the service isn't being waived; it's just being executed by us instead for someone's financial hardship. And to be clear, this isn't really a change in the way things are done. this is, I think, just a better description of what's actually happening, as opposed to service being waived. The service still has to happen, and it is still happening.
I think it's a very logical change, and I think we drafted it poorly back in probably like 2000 or 2001. The concern came up then. Prior to that time, the Loft Board had done the service. So the responsibility for service was transferred from the Loft Board to the applicant. And the concern came up, well, what if the applicant can't afford all that postage and copies, and some of these are big buildings? To my knowledge, I don't know that this has ever been invoked, but certainly describing it as service by Loft Board staff rather than a waiver makes all the sense in the world.
Great. Yeah, that's the kind of history that's very helpful. And then so following into that, the line underneath in 1, similarly changes the language, whereas the current version says the Loft Board staff may waive the requirement. It now says we could say the recommendation is that it say the Loft Board staff may serve all affected parties if the applicant proves that the applicant does not have sufficient funds to complete service. So it's just a consistent change to the title that I mentioned. Thoughts or comments on that? So what I will do, I think, is based on these talking points, I will be presenting a version that now actually incorporates the changes we're talking about. And you will know where to find them, and you will know what they are from the context of this conversation. And then if I can figure out, and I think I have now, how PDFs work a little better, I can try to put the suggested language right on top of this version. So that's going to be my advancement in technology for next time. Any other questions about what's on page 17 with the waiver of the service by Loft Board for financial hardship? Okay, so there is another item on page 17, and it's in the next section. So from what I saw in a few different places, there's language that discusses it's D2. To request a waiver, the applicant must submit a hard copy of the application containing an original signature, comma, an electronic copy of the application, and a written request asking the Loft Board going on. The electronic copy piece, the way this reads, puts the electronic copy as a requirement of the submission. And Law Department has said unequivocally that requiring an electronic submission is not compliant with the state law. And so I would guess that there's just a desire to do things electronically because it's easier for many parties. I do not think that there would be an objection to making it an or type of statement. And then there's some other parts on this section, but I'll stick with that piece of it for now. Does anyone have thoughts on, basically, the difference between requiring an electronic submission and allowing an electronic submission? I think allowing it as opposed to requiring it's a little more egalitarian. You'd like to think everyone has technology, but if they don't, I don't think you'd want to dismiss their application over it.
It's definitely good to encourage not less use of paper from an environmental standpoint.
Mm-hmm.
But yeah, I understand technology issues.
So as we were looking at this, we actually started dissecting it, and the other changes you see to the language really aren't really a reflection of Law Department's comments, but our staff looking at it and going, well, the way it's written is a little muddled anyway, and and so it's been reworded to say, and I'll read it aloud, but you might need to look at it a few times. To request service by the Loft Board, the applicant must submit a written request asking the Loft Board staff to serve each affected party, attached to a hard copy of the application, containing an original signature or electronic copy of the application. The reason it was switched around, and I'm going to ask Mr. Clark or Ms. Lynn to help me mutter this out, because it's easier. It takes more words than it should. But the way the words were organized, it wasn't clear where the signature is supposed to go on which thing, and so it's an effort to, even if it's a little more dense, to make it clear. Where the signature goes, which document is which. I can try to explain it better, but it gets, but I'll need to take a few minutes. Our goal is to have it say the same thing in a way that is not ambiguous, and that we think we achieved that. This has not been run by law department. This is a comment that this is something that the board's staff identified. Ms. Lynn, Mr. Clark, do you guys have any other helpful comments on that piece? I know you were on the phone when we talked about it. Okay, thanks everyone.
I would just ask, this is in section 2 at the bottom of page 17. We would be changing the first sentence.
And the second sentence.
So this would be this total of section 2 now.
Let's see, of such application, where the word, no, the first sentence. Only the second sentence remains.
The applicant may file the hard copy.
Second and third sentences remain.
Right, okay.
Yeah, only the thank you for that. Yeah, this is I wasn't clear. A replacement of the whole of D1 and the first sentence of D2. And again, I at this point I think I might regret my strategy. I hesitated to put edits into the edits, lest it be confusing which is which, and later it becomes more important because it gets confusing of which one's old and new. But what I will be doing is incorporating what we talked about here into a version that will reflect the changes that we talked about. I guess I'll move on to page 18, which again finishes D2, but does not. There's no changes in that highlighted portion in the rest of that. So the next one is again
Kevin, I'm sorry to interrupt, but before we go on, are there other places beyond this particular, what we were then calling a waiver, where we require the filing of both a hard copy and an electronic copy?
Yes, I think it comes up in 2 other places.
And we'll be getting to those?
Yes.
Okay, thanks.
Yes. On page 55 and on page 51. And it's a similar fix. In fact, I think a simpler discussion, because you didn't muck with the language separately to try to make it more clear. So yes, it comes up 2 more times. On page 18 of our draft, in the same section D, but now we're in 4.
I'm sorry, Kevin. I'm sorry, Kevin. Before we move on, I was looking at it again. That section, why we reworded it. I'm sorry if you didn't, if you've already said this, but I think it was an issue of it kind of confused the reader into making it think that they had to submit an electronic copy. And the reason why we reworded it is so that it's clear that they don't have to submit an electronic copy.
Yes, thank you.
I think or by fax ought to come after email.
Let's see. What page are you on, Mr. Berowitz?
18?
On 18? Oh, or by fax. Oh, so adding at the end. Wait, sorry. Make this.
Application may file electronic copy by email to an address provided by the Loft Board, or by fax should come after email.
It wouldn't fit like that if you, unless, you know, because it fax goes by a number, email go by an address. So I think that's why it's like that, Mr. Horowitz.
Kind of email to an address provided by.
Well, it just makes the language clear. It's not a big deal. I would.
Maybe you should put, maybe to address Mr. Borowitz, you could say the application may be filed by fax, or by electronic copy, or electronically by email to an address provided by law, something like that. But I don't see anything wrong with the way it is right now, Mr. Borowitz.
Okay.
If you the way you want it would create more rewording. What do you think?
I think Mr. Barowitz said, oh, you know, okay. I don't know, but I'll pause to make sure if there's any other comment or thought. Okay.
Mr. Barrows, we could stat that. We could leave it.
Anyway, I would withdraw my comments.
Okay.
Anyway.
All right.
Doesn't matter.
So the later on page 18 in this same section, there's a section 4 that discusses the Loft Board staff will notify the applicant of his decision, and then if it discusses if the last sentence, if the Loft Board staff denies the request, this is a request for service by financial hardship. It says the Loft Board staff will return the hard copy of the application to the applicant, so the applicant can serve each affected party. I think I need to interact with law department a little bit more on this, because they suggested that this be stricken. I disagree. I haven't yet spoken with them about it yet, but I did keep it on this list to note for you all in case anyone had thoughts as to why the rule's better without it, or if I'm kind of misunderstanding the suggestion, or if there's some history on this language that anyone remembers. I think, and again, Ms. Lynn, you helped me kind of decode this a little bit, but it seemed to me that this is there so that once we say we won't do it, you must do it. So I think striking it eliminates that clarity, but perhaps law department wants to avoid unnecessary language. Again, not sure. I am inclined to go back to law department and say, I'm not sure why we're deleting this. If anyone has any different thoughts, I invite you to share them, please. All right, so I will have to get back to you on that one. Let me rephrase that. If it turns out law department goes, okay, got it, no, I get it, then you won't hear another word about it. If they articulate something that I need to share, I will. Continuing to go through, if there's no other comments, on page 29 of our draft version that we passed. Another easy one, but I'd be clear, I didn't want to take anything for granted. I did not want to walk into this and make changes without letting you know.
There's some highlighted on page 24.
Oh, let's see. I think so. Okay. Oh, sorry. So on page 24 and on page 27. I'm sorry, affected party. So on page 24, there's another example of affected party that needs to be capitalized, similar to the first note. And likewise on page 27, twice. Thank you, Ms. Rosalind. I don't want to skip over anything. As I was saying, I wanted to be so meticulous. I ended up not being very meticulous. On page 29, This is a format concern, essentially. The word code compliance deadline is bolded, and it's not consistent with the rest. Taking nothing for granted, if anyone remembers why it was bolded or thought it was important to be bolded, I want to invite that conversation. So law department has recommended it be unbolded.
So isn't the reason for the bold because something is defined? Is that usually?
Yeah, and if you look above, there are many items that are bolded and in quotes that are consistent with a series of definitions.
Right.
And then this one is consistent with kind of a new section. It's not enumerated in any way, and I think we're in the section now in section 2 where we're not starting from scratch. We're working with what's already there. So I think to keep the feedback as minimal as possible, basically trying to say bolding is for defined words, which this is not. Italics would be called for with a section heading.
Okay.
Which if you look below is what you see.
Okay. So be it then.
All right.
Well, I'm a little confused now. The top of that page 27, and the very bottom of page 28, we had an entire section called definitions, and what we were proposing to do originally was remove all the definitions and then go to code compliance deadline, which is not a definition, right?
Yes. So you hit on something that I did not put on today's agenda because it was big and I needed clarity. But I'm actually glad you brought it up because I'm happy to talk about it briefly. Throughout the rules, there are sections where words are defined throughout. And law department generally is of the opinion, I wouldn't even say generally, I'd say explicitly of the opinion that those definitions don't belong anywhere but in the definition section at the top. And I think my understanding is that this board preferred definitions be placed in places where they are accessible and useful, whether new or repeated. That is the version that we passed, and I think law department still wants to talk about that. So since you brought it up, I thought I'd share that notion, but I did not put it here to dissect.
No, my recollection is we've been down this road and discussed this many times in the past few years, and we kind of opted to put everything that's always the same in definitions, but there are still a few places where in a particular section of the rules, a word means something different than that which it generally means.
Okay, that's helpful, very helpful. I'm glad you raised it because I think and I want to hear the rest of the board, I should say, unless anyone remembers it or disagrees. I think that sentiment will resolve many of the comments potentially that law department had because they did point out, why are we repeating this definition, for instance. So if we don't need or want to repeat a definition, which I think is the rulemaking way, I think we benefit. Now, if a definition belongs in a place or it differs for specific reasons, perhaps, I think there is for lack of a better word, a repetition, and those need to be dissected case by case.
Well, it does say when used in this section, the following definitions apply, unless context clearly dictates otherwise. So does that mean, so do we have to go back and compare the definitions, these 1, 2, 3, 4, 5, 6, 7, 8 definitions here against the definition of the same word in the general definitions section?
Just to make sure I'm looking where you're looking, what page are you on?
28.
Okay, so that language on page 28 within brackets there.
Well, it's an
So-
open bracket
And it
to the,
closes after occupant.
after, yeah.
So I think, you know, and I guess to be clear, what Mr. Delaney said is accurate here. Those definitions have been removed by the brackets in this space. So they are not there. They will not be there in the final edit. I suppose that I referenced them, and I regret that. I was referencing them as a point of comparison, even though when it's passed, they won't be there anymore. If that makes sense. So the way definitions look on page, I gotta go all the way back, but on the very beginning section is what they will look like, and I think that's what they look like there too, if I'm making sense. They do not have quotations on them. If you go to page definitions on page 5, 6, so quotations have been taken out, but bolding remains. And so, yeah, I apologize for referencing the quotations because that's actually that will not be the way definitions are up here. Now, I guess, Mr. Roslin, you mentioned that language about unless otherwise defined, and that does appear on page 5 in the new version. As used in this title, unless otherwise defined, the terms below have the following meanings. And so that speaks to yeah, what Mr. Delaney mentioned, that it's being moved up, except for in places where it might need a special definition.
Okay, so to be clear then, this whole section is amended to read as follows. So it's all part of A.
Yeah. What page are you on?
Back to 28.
Okay.
So we're looking at a comment on page 29, but if you take out the definitions, then code compliance, the paragraph that begins with code compliance deadlines would be right after the paragraph that begins with code compliance timetable.
Yes, and it would be below the words and regulations.
Which is all part of subdivision A of section 2-01 of chapter 2 of title 29.
Yes. You know, whether or not it deserves a B or something, if that's the question that's being begged, I can look into that. I honestly don't know.
It's kind of where I was going with it, yeah.
Okay. Unless anyone has the answer abundantly in front of them, I will return with a recommendation as to whether or not to add a B before that sentence, before code compliance deadlines in italics. I mean, I honestly don't know. I don't want to speak out of turn. I don't want, but it seems fine to do so. But I don't know what I don't know. So, any other thoughts on what we talked about on page 29? Italicizing and potentially putting a B there.
I'm curious as to why the law department wouldn't have picked up on that.
Yeah, there's a lot to look at.
Not as perfect as we are.
Exactly. Thank you. Yeah, no, I think that's a fruitful discussion. It does beg for maybe a letter there. Moving on then, if it's okay, to page 43, which is another instance where there's three instances of this. The word reserved is not, it's supposed to be in capital letters. There's some other stuff about the word reserved that I think we get to today or not, but to keep it simple for right now, if and when we're going to use the word reserve, it is to be in not in all capital letters. If anyone has a concern, please speak up. But to me, it seems fine. And that's on page 126 and 144 as well. I'm going to slowly move on to page 50, and if anyone wants to speak up, please do.
You know, once again, I'm nitpicking. I would move the word reserve to the middle of the page.
Sorry, you would move say that again. I'm very sorry.
I would put the word reserved, all caps, that's fine, in the middle of the page rather than on the far left.
He would center it.
Center it. Center, and it would actually not be all caps. But okay.
Either way, that doesn't bother me so much.
I'll ask law department. You know, I really would be remiss to predict what they think of that. But I'll bring it up. It's
okay.
You tell them Mr. Barr says that's what he wants, and they'll sure to give it to you.
All right. There you go. And obviously, if we do it there, we do it elsewhere. Page 51 has a few things on it. Well, page 50 actually includes another event of the affected party word, that phrase not being capitalized. So again, with it being a defined term of art, we are inclined to capitalize it throughout. Page 51 has 3 more instances of that at the top. And then in the middle, where you see section C, this is the second example of where law department advises that we cannot require an electronic document. So here the change was hopefully and arguably simpler, and it was changing the and to an or. Party must file 1 hard copy or 1 electronic copy. Which would just be consistent with what we already discussed.
And is there ever a situation where someone would file both or want to file both, or we would want them to file both, or we wouldn't want them to file both?
I think probably not. As it occurs right now, people who email it to us send it to us through the mail also because they're required to. And they send it to us over email, I think, because they just know it'll get to us quicker, and hopefully we'll get to their business quicker, which is true and fine, probably. I suppose I could imagine, and in this modern time, I don't think we've lost an email application yet. So if it only comes via email, I think we're good with that. And if it only comes in hard copy, we're already handling things that way. So I am inclined to say no. I think either or is fine, and both is superfluous to our process.
I have 2 questions on this. Number one, in response to the very valid point that Ms. Hayashi made earlier, is there a way we can express that we would prefer an electronic copy?
Yes. The short answer is absolutely, but probably not in the rules. Probably on the form. Please, you are encouraged to send email rather than mail if possible, as to save the trees. I think our form could say that. Our form is ours to create, and as long as it's not a requirement, I do not think that would be a problem.
Oh, what's wrong with putting language like where is it? File an electronic copy, or if that is not, if the ability does not exist, then you may file a hard copy.
Because that language will get misused in some way by lawyers. By trying to save the trees, someone will weaponize it.
Okay.
All right, I would then just put the electric copy first.
That's what it is, yeah.
And a hard copy afterwards.
There you go.
Right. 1 electronic copy or 1 hard copy. That seems doable.
That's perfect, Mr. Burrows. I think people remember what they read first, right?
Yeah, that seems very doable.
And I said I had 2 points. The first one we've covered. Thank you, and I agree. The second one is in the materials you sent for this meeting, Kevin, you included the draft of the business analysis and risk assessment. And this kind of touches on that. Are we going to go over that document at some point?
Yes, if you'd like, and as time allows, I shared it on purpose, even though I'm not sure I had to, but I was happy to. That document, and I was going to mention it, so thanks for bringing it up. It's a requirement of the Electronic Signature Act, ERSA, and it's something that Law Department has been saying as they're making these comments every time. Do you finish your BARA? Do you have your BARA? And so what this is, this business analysis risk assessment is something that is required of government agencies when they have decided in rulemaking to accept electronic documents. Because and appropriately so, what the state has said is if you're going to do that, you need to have a process and,
Right.
to do it in an effective way for mostly looking at signatures. And so beyond that, there isn't much of a requirement other than having one. And so what the draft that you have is crafted from some examples we saw, some guidance that the state gave, and the realities of the way I come to understand our unit works. And so it is not part of rulemaking per se, so it does not need to be passed by the board per se. It does not have to go through CAPA or the law department. It's amendable as needed. It's basically a protocol for our unit, for our staff, and so we can change it if we need to based on reality. But I did decide to share it in the context because if you were interested, I wanted you to know.
Oh, I'm glad that you did. And having read it, when we have the time in the next few meetings, I would like to go, because it raises some interesting questions to me. Maybe that's a sign of personality disorder on my part, but it does raise some interesting questions.
Okay. Yeah. Okay. So yeah. So I'm glad you brought it up because it was a document sitting there maybe without much context, but it's an outcrop of the comments made about electronic signatures. Page 51 again. So we're going to switch the word electronic and hard copy. We'll change the "and" to the "or," and then we could move on to page 55, which is the same issue. And we can, I think, do the same thing.
Okay.
There's also a bunch of affected parties on there. The word affected parties. So file 1 electronic copy or 1 hard copy.
Okay.
Page, let's see, it's 55. Page 56 includes another incident of the word affected parties to be capitalized. Now we're on to page 61. So this is a issue of rulemaking markups, and what Law Department identified was that hyphens were added without indicating its addition. And so this is, to me, evidence of the meticulousness of our lawyers, and I appreciate it. You shouldn't add a hyphen without flagging it appropriately in rulemaking. So the change would be to underline, delete the word non-residential, no hyphen, and replace it with the word non-residential hyphen. And that the hyphen is consistency with other parts of the rules. And that shows up 3 other times. And if you are rolling your eyes, it's okay. But again, I want to leave nothing to chance with any changes being made with you folks. This is evidence of the meticulousness of the review by the lawyers, as well as.
Sorry, I'm sorry for my facial expressions. I can turn off the camera.
I rolled my eyes as well. Believe me, I am rolling my eyes as I'm saying it. I'm not.
Anytime you need me to turn off the camera, Kevin, you just be like, Samira, I don't need to see that. I'll be like, okay.
No, it's understandable. Yeah, no, it's understandable.
We had a loft board chair some years ago who used what I guess is a legal term of art and referred to this kind of minute examination as fly specking.
Was it fly specking?
Yes, fly specking.
Well, here's a fly specking.
I'm rolling eyes. Yeah, right.
I don't know what non-residential occupants means. I have no idea what that means. Non-residing occupants, maybe?
No, I think this goes back to commercial and
No,
manufacturing.
If you're not a resident, how could you be an occupant?
I think it's commercial or manufacturing tenants.
Well, if that's what it refers to, then it's okay.
Yeah, I think it does refer to.
Refers to people that are working in the building but don't live there. Is that what it refers to?
Yeah, it refers to occupants who. It's really just meant to be everyone who's not a residential occupant, and a residential occupant are the people who live there. So yeah, the people who work there. And I think it's meant to be as broad as it can be, rather than saying manufacturing and commercial, lest there's some other word that's being missed there. I think it's just meant to mean everyone who's not the people who live there. And this is not a new word that we're adding or changing.
Okay, all right, I agree. Let it go.
I see what you're saying, Mr. Barwitz. Yeah, but yeah.
I agree.
Yeah,
and this was tied into the legalization plan, and the concern was if something's going to happen to the elevator or the heat ducts are going to be moved around, that should be notice should be given to everybody who uses the building, not just the residential occupants.
If you go to page 62, you'll see the reason why, actually, non-residential units. Reference there. So the occupants of non-residential units are non-residential occupants.
Yeah, and so that this page 62 is, now that I'm looking at it, a little bit different in the way work performed on the.
Units would be much better.
Say again. Sorry, what's that?
To replace occupants with units would be much better. Be clearer.
That's a conversation we're set to have at the very end, and I put it at the end on purpose because the words units has in that context has some concerns by law department. So I'll put a pin in that suggestion because it invokes the concern by law department in another part. Maybe I'm misapprehending what you're saying, but suffice to say, not to get ahead of it, but when you're trying to talk about people and you start talking about units, law department didn't care for it. But maybe it's not as big a problem here. But actually, on page 62, it does refer to non-residential units. Can I move on to page 86? On page 86.
83?
Oh, did I skip one?
Yeah, 83.
Oh, 83 has some yellow highlighting. That actually wasn't done by me. This is just to flag when we finally pass the rule, we'll need to include the effective date of the rule because that's the operative date for that section. So there's nothing to discuss there until we pass the rule. And it's in, no, actually it's in, why is that highlighted? That is not one I highlighted, I don't think, is it? Did I confuse myself? 83. I'm going to get back to that one, folks. I apologize. I do not remember highlighting that.
I think you were correct, Kevin. Once this is all passed, you're going to insert a specific date there. You didn't highlight that.
Okay, after. Yeah, that. Well, but it's bracketed, which means it's going away, which does confuse me. So I need to understand that better. Do you?
Well, it means that you will not say effective date of the amended rule. You will be putting a specific date there.
Oh, well, then I don't understand why September 11th, 2013 is there without a comma after it.
Because that's the last time we amended the harassment rule.
Right.
And
Okay.
unlike the various timetables and things that apply to different sections of coverage like 281, 281.4, 281.5, for the harassment rule, all cases filed after whatever that date will be, these rules will apply to all those, all future cases.
Yeah, I understand now that so I'm not sure it needs to be highlighted then because we're not going to be adding a date in there. This is just going to be stricken.
That's right.
September 11th, 2013 will no longer be the effective date of this rule.
That's right.
Right.
So what should be highlighted there is September 11th, 2013, so that you know to change that date.
I don't know if we want to change that date. And I say I don't know. I literally don't know. I'm not. I don't want to jump on the idea.
They were just initially saying that you don't need to have the words, the effective date of this amended rule, to in referencing September 11th, 2013. They just, that's why they're taking that phrase out.
Right. Okay.
That sounds like the law department to me, like, but maybe it's just not necessary.
Yes, that's my takeaway. I'll flag it and take a look at it with staff to make sure we're doing that right. And if there's nothing to highlight, I'll unhighlight it. If there's something to talk about, I'll try to make some talking points on it.
Just again, to provide a little historical context, it's my impression that there were no substantive, that in these revisions, there's no substantive change to the harassment rule as it currently exists, that we've got a lot of capitalization and for terms and all that good stuff for form. But many years ago, when the harassment application was first adopted in 85 or 86, it had a bunch of different requirements that we did make substantive changes on. So I think the purpose of that September 11th, 2013 date that's currently in the rules was to make clear that the newer rule that came into effect on September 11th, 2013 would be the version by which all cases filed after that would be decided, but there were probably some that were in the pipeline.
And if I'm following, there's no desire to change that date. As of today and tomorrow and next year, it can remain September 11th, 2013.
Well, that depends whether we think there's any substantive changes here that would make a case that's filed today different from a case that's filed whenever, we finally passed this bloody thing.
Right. And again, I'm working only as like a detective here from looking at what I see. The markings as indicated would indicate that that's what this board must have wanted at the time. And it's supported by a glance at the harassment section that does look to have only, fly specking type of changes.
You're
So
loving it, right?
I don't want to take it for granted here, especially since it ended up yellow highlighted, and I'm again not sure how. But it looks to me like there was not an intent to change that date to become the effective date in this case. So, if any members or staff remember anything differently, let me know. Otherwise, I'm probably going to rely on the marking as it shows. But I'll also check it with law department to see if there's a reason why that got flagged the way it did. Page 84 has another reference to this word non-residential. Again, the hyphen got added without the proper markings. It's something we can fix. Page 85 so this one's weird. So what you see in front of you in yellow does not indicates neither what we should do, nor does it indicate what's actually in the rules right now. So oddly, the physical text of the rules includes brackets around the word residential. And I don't want to belabor this too much because your time is valuable. But at the end of the day, the law department is going to work to let us know how to remove brackets, presumably by using brackets. So I anticipate indication of a change on that, because what you see in front of you represents a change made without indicating the change, but it's not clear how to make the change. But it's all about brackets.
You said residential. Do you mean reserved?
Reserved. I'm very sorry. Yes, the word reserved. Thank you, Mr. Laney. The word reserved.
You had me going there.
Sorry. The word reserved is the word that should have had that has the brackets around it in the current active version, which is essentially just clearly a mistake of prior drafters. That word, the bracket shouldn't be here. So it does beg the question. And again, I'm not sure why. I don't know enough to know why there would be strong opinions on this, whether or not we want the word reserved in there or not in this space. If anyone recalls conversation as to why or why not to have the word reserved here, let me know. Otherwise, I don't yet have a grip on why it matters. If I'm being honest.
Was something there before?
So the current rules show the word reserved with brackets around it.
To be taken out.
Which indicates to me that when the final rule got passed, someone forgot to delete bracket reserved close bracket. But
So
now
the way this is written, or with there's no brackets around it now, it's just saying, so little I would be that first paragraph, and then it was 2 little i's was reserved and 3 little i's was the loft board finds, and now the loft board finds is just going to be 2 little I.
Yeah, so there's no, I think if I'm looking at this correctly, there's no opening bracket.
Right.
And so I think maybe I could have asked the question better. Do we want the word reserved there? Why or why not? That will tell us where to put the first bracket.
Kevin, it is kind of clear that reserve should be taken out. The reason being that if you look, the brackets from 3 little i's are taken. I think that there's just a missing bracket, open bracket.
Okay.
The open bracket is missing. It should have been over 2 little i's on the side, because the new text should read 2 little i's, because that's underlined. Yes, you got me? Or did I misconfuse you? I think it's taken out because it's there's a closed bracket without an open bracket. You see that?
Yes.
Okay, so the open bracket is missing.
Yes.
And it should be before reserved and starting off with 2 little I's. Miss Ayashi, are you laughing at me? Or I'm trying to, I got you. No, you deserve, I deserve to be laughed at with all these open brackets,
No,
closed
it's,
brackets.
I,
But
It
yeah,
just,
I think
it
should.
just so happens, and I'll entertain offers. I guess I could post this on eBay. I've got a set of the rule draft from about 2019.
oh,
And in that instance, we had, we were proposing to remove the double I. It had a bracket on both sides. The reserved was crossed out. And that's because the law department had provided a comment saying any reason we can't renumber these provisions. And Helene's response was, can we reserve, I'm paraphrasing, can we reserve this section so we don't have to cross-check references? The changes are complicated enough as it is without making them more so and creating more chance of error. Law, you can leave the subparagraph unused, though it is my understanding the publisher adds reserved. The agency would just leave it out or just include little double I, but I will refer to Steve Goulden on the forms issue. Given the fact that you only have to change one designation, I'm not sure why you wouldn't want to do this in this instance. So there's a whole history of.
yeah. Thank you for that. So that was helpful because I do remember seeing similar notes in other places. The value of keeping the word reserved there is to keep the integrity of the ordering for referencing, because people have been referencing these things for years. So yes.
And I would just take a moment to add to those of the newer members who think that deciding cases is fun and interesting. We've spent hours doing exactly what we're doing now over the past 2 years. This has gone on so long, and it's so, dare I say, tedious.
Sorry. Hello? Uh-oh. I believe we have
up a lot.
Rose there a little bit, Mr. Delaney, unfortunately.
I want to see
I heard you up till tedious.
2 and just start with if the law board finds that an applicant has filed a harassment application in bad faith. Yes, is that what we're planning to do?
So my computer is glitching. I'm losing words, unfortunately. I went from Mr. Delaney speaking to Mr. Barowitz speaking, and I missed the beginning of Mr. Delaney, the end of Mr. Delaney, and the beginning of Mr. Barowitz. I heard Mr. Delaney explaining that it's tedious, and then I picked up in the middle of Mr. Barowitz's sentence, so I apologize.
Mr. Barrows is just asking, what's the decision?
I think the decision is, I think for the reasons that Mr. Delaney mentioned, I think keeping the word reserved there makes sense. I think it's easy enough to market that way, and I don't think law department will care.
So if we do that, then it's not 2 little I's that's underlined. It should be 3 little I's.
Yes.
Okay.
Mr. Delaney, that tone of yours is very impressive.
And do you need to move over, tab over 2 little I's in line with 1?
Yes. Yes.
Okay.
So it would be, the 2 little I's would be the word reserved, and then the 3 little I's would be the section that starts with the words if the loft board finds.
Okay.
All right. And I'm not sure that that answers the question. We want the word reserved there, and the law department will help us make it happen, because there is a weird bracket in the existing rules, but that can be worked around. It's essentially we're going to be deleting brackets with brackets, I think, is what's going to happen. I know we're not done yet, but I'll say thank you now to everyone for hanging in with this.
How much more do you think you may have, Kevin, that could possibly be done in 2 minutes?
How long does our meeting go? I'm not, that isn't a joke. Are we, are we supposed to be done at 4:30?
Yes.
I would like to respect people's time, yeah.
Oh, okay, then let's stop because we're not going to finish per se, and there will be more to talk about next time. And I think what's more important is to express that the chairperson advised me that we'd like to try to do a special rulemaking meeting late October and early November. I do not need to schedule that with you now, but stand by for that outreach. Sorry, I wasn't watching the clock, so we can stop here.
Thank you. That's excellent. Thank you, Kevin. I didn't mean to rush it, but
I was all excited. That's okay.
Kevin, before you end the meeting, incidental, I'd like to ask Chuck, I didn't quite follow you what Gail Brewer's position is on Soho, NoHo, Chinatown.
She basically said it needs a lot of work, and rather than make a formal declaration during her review period, she kind of kept silent and then herself testified in front of city planning, stating that she was fundamentally opposed to it in its current language.
All right, I did send a rather long note to her, which she hasn't responded to. But okay, I'm glad that you clarified that. Remember, it's not Soho, NoHo anymore. It's Soho, NoHo, Chinatown.
East Chinatown, Chinatown East, right?
The area on Broadway and that goes all the way down to Chinatown, or 1 or 2 blocks west is the Chinatown area, so-called, in the Soho, NoHo, Chinatown rezoning area.
thank you, gentlemen, and thank you, ladies and gentlemen, for a rather productive board meeting, actually. And I want to thank the staff led by Kevin for all of this, and I appreciate you guys. I didn't say initially when you came back, welcome back from the summer. Quite a bit. It was quite a summer, but I really I'm happy at least that we could accommodate more people and more participation via this teleconference route. So I do appreciate while it's not I guess it's an exception to the rule, but this does allow a lot more participation, I think, even from the public's point of view in these meetings. So thanks for that, and I appreciate the hard work here by everybody in getting this.
Mr. Chairman,
yes.
Before we adjourn for the day, I would like to make one request, which is we put on an agenda in the not too distant future a discussion of what the board's policy should be with regard to unsolicited communications regarding cases before the board.
Kevin, you got that?
Yes.
Yeah. All right. So be it. Thank you, Mr. Delaney. This will conclude our September 23rd, 2021 Loft Board meeting. Our next public meeting will be held on October 21st, 2021 at 2 p.m. The governor's suspension of the in-person meetings requirement of the open meetings law is in effect until January 15th, 2022. So at this time, we anticipate that the next meeting will be held virtually, as is now. Information will be updated on the Loft Board's website, and also an email update will be sent through the Loft Board announcement listserv. Loft Board members, please sign and email in your attendance sheet, or if you wish, you may present it in paper by dropping it off or mailing it in. All right, thank you very much, and have a great rest of the month. Take care, guys.
So long.
Bye, everyone.
Thank you.
Bye.
Bye.
Bye-bye.